case, there were two Russians, Vasily Gorshkov and Alexei Ivanov, and what they did is they would break into U.S. corporations, steal credit card numbers, and then contact the corporation and say, I have some credit card numbers of your customers, and unless you hire me as a computer consultant at a certain wage per year, then I'm going to publish this on the internet, and your stock's going to go plummeting down because everyone will know that you can't even keep your customer data secure. So a lot of companies, in response to this, they actually paid the money. But one company said, we're not paying. And so they contacted the FBI. So the FBI set out to basically a sting operation. First, they called Russian authorities and said, would you help get these guys to be extradited to our country so that we can prosecute them? And Russia said no. So then they said, okay, fine, we'll do it ourselves. So what they did is they set up a corporation called the Invited Corporation to invite these two individuals to come to our country. They set it up in Seattle. They sent them messages saying, we heard that you have exceptional skills as a computer security consultant, and we're wondering if you'd be willing to work for our company. If so, would you please fly to Seattle and interview with us? So they flew to Seattle. When they got there, they said, well, before we hire you, we'd like you to demonstrate your computer skills. Would you please use this Invited laptop to show us how you can hack into people? So they said, well, we left all of our tools in Russia. And they said, that's all right. Go ahead. You can get them, and download them to this computer and use them. So they used the Invited Corporation computer, which had a keylogger on it, to sign into their site in Russia, download their tools, and then show that they had these good hacking skills. Well, the FBI had sealed indictments against them, so as soon as they had their user ID and password, they were seized and taken away. Then the FBI went back into their place in Russia and downloaded several gigabits of data to use against them in their trial. Now, after they downloaded it, they secured it. Then they went to a federal court judge and said, we would like a search warrant to search this data. They used that search warrant. They searched the data, and they used that data to prosecute them. At trial, Gorshkov said, wait a minute, Fourth Amendment, you got the search warrant after you already got all the data, so therefore you should not be able to use the data against me. How many of you think that this was a Fourth Amendment violation? Raise your hand. How many think it was not? Okay. In this case, the court said it was not. The reason they said it was not is, who would you get a search warrant for to search computers in Russia? Okay, we have no judges that have jurisdiction over Russia. So there's no way you could get a search warrant. So the court said the Fourth Amendment applies to people within the United States. It does not apply to people outside the United States. Now, in rare situations, it could. If a U.S. military member is abroad, for instance, and U.S. personnel are trying to do something to him, it still would. But generally, it doesn't apply outside the United States. So the court said, actually, we think what was done in this case was the best thing. They pulled it into the United States, but then sought a search warrant before they used it. Now, I will say there's a little bit of a problem here, and that is, a keylogger does what? It records every keystroke. If you're communicating overseas, what you're doing then is not just pulling data off of a computer, you're actually recording a communication. In the United States, that requires a higher order called the Title III order, not just a regular search warrant. They didn't have a Title III order in this case. And so some might ask, well, wait a minute, how did they do the wire intercept then? So I asked some of my friends in Department of Justice, I said, how did they do this? And they said, oh, well, they had a consent form that they had to click through on the computer before they could use it. And I said, oh, okay, so they clicked through that consent form, and he said, well, actually, the undercover agents got a little antsy, so they went and clicked through it before and then gave him the computer. Okay, now does that create any problems? Okay, now the agents consented to the interception, but they haven't. Interestingly, though, neither of them raised the interception issue, so it never became an issue at court. But it does create some issues potentially for future cases. Okay, now this is an interesting case. For the longest time, the Department of Defense had a banner that whenever you go down to any Department of Defense system, you click through it and it says, I consent to being monitored, I know you can search everything, blah, 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 blah. This is a government computer. And I understand that you have something similar, although it may not be implemented in a banner, it may be implemented in a user agreement that you sign at the beginning of the semester or something like that. So we had one of those, and but while that was in effect, a Lance Corporal Long, Lance Corporal is a very junior rank in the Marine Corps, She found out that she might be called to give a drug urinalysis sample. In the military, you can be asked at a random basis to give a drug urinalysis sample because they want to make sure that military personnel are not using drugs. She found out that that might be happening, and she got very nervous. So she got onto her Marine Corps computer using the Navy Marine Corps intranet and sent letters or emails to her friends saying, first of all, does anyone know how good this drug test is? Could it actually detect my use? And secondly, if it can, does anyone know any good masking agents that could mask it for this purpose? Well, as soon as the investigators found out that she had sent those emails, those are obviously very incriminating. So they went to the system administrator and said, would you please retrieve these emails for Lance Corporal Long over these dates? They did. They were used at her trial. At trial, she said, I object. You know, I had an expectation of privacy in what I use on the computer. Now, the military judge said no. He said, you click through the banner, you have no expectation of privacy, so all of it comes in. She appealed, and at the Navy Court of Criminal Appeals, they said, no, we believe that she did have an expectation of privacy in this case, and so therefore we're going to overturn they were going to overturn it, but they said there was so much evidence anyway, she still is guilty. So then it got appealed by both the government, who said, no, we shouldn't have had to do that. And then secondly, she also appealed saying, no, if they did it wrong, then I should be free. So on appeal, the issue is, does a military member using a military computer over a military network have a reasonable expectation of privacy in that use? How many of you think yes? How many think no? Okay, and that's what we all thought, and you would all be wrong. The United States Court of Appeals for the Armed Forces, which is the highest military court, one step below the Supreme Court, said that there was an expectation of privacy based on three things. One, she was told to come up with her own password, and she was told not to tell anyone that. And she thought, if I have my own password and no, I can't tell anyone, then obviously I have an expectation of privacy and anything behind that password. The government argued, no, the system administrator can go right around that password. He can change the password. It doesn't matter. Everyone's given a password. It doesn't matter. The court said, no, we think it's important nonetheless. Now, this was the part that killed the government, however. When the government brought her emails in at trial, they asked the system administrator, are these the emails that you retrieved for us? And he said, yes. On cross-examination, the defense counsel said, do you always read everyone's email? And he said, oh, no, because I think they're private. Okay, so now you have a government witness saying he thinks they're private. Now that's a big stake in the heart there for us. And then the final one was they said, we also think the banner was weak. We think the banner was written in such a way that it only gives a very limited reduction in the expectation of privacy. So based on that last one, what we decided to do is retrain all of our system administrators so they wouldn't do that second error. The passwords we actually address in the banner now. When you click through the banner on the DoD system now, it says you will be given passwords, encryption keys, and other things, and these have no benefit to you. They are only to protect government communications from others, not to protect your personal communications. So we did a lot to modify the banner. The federal agencies who followed us on our earlier banner are also changing their banner to match this. We are still having some issues, however, with attorney-client privilege, because within the military we have attorneys who advise defendants. We also have clergymen who discuss things with penitents, and we also have psychotherapists who discuss things with their patients. And all three of those have a privilege, and all those privileges require some type of expectation of privacy. So they were complaining, saying, whoa, wait a minute, now that you've made it really clear I have no expectation of privacy, how do you expect me to communicate with my clients? And so we had to put a little extra thing in the banner to accommodate that, and that has made it a little bit more confusing, but hopefully it'll all stand up. Okay, so just a few months after, probably about 18 months after that case came down, and before we had a chance to change the DoD banner, this case came down. A reservist major who was filling a desk for a deployed officer over in Iraq, he was staying stateside while the other officer went abroad. He apparently was bored at his desk, so he started soliciting sex with minors. And he did this in such a way that it obtained some notice by the local law enforcement authorities, not the military, but the local. So when he went to meet 14-year-old Kristen, who was actually an undercover cop, they arrested him. And then they called the military base and said, hey, we just thought you ought to know, we have one of your majors in jail down here for trying to proposition a 14-year-old over the internet. So the military was very concerned about this, and the commander said, okay, well, I want his office searched, and I want his computer searched to find out what the heck he's been doing while he's been at this desk. So they did, and they found additional incriminating evidence against him. So he moves to suppress the search of his office and the search of his computer, claiming he had an expectation of privacy. Now again, this came down after the Long case came down, which I just told you about.